Welcome to our attendees and welcome, Graham. This is our sixth webinar in a series for the California Psychedelic Bar Association. And just a quick note for our attendees that we are recording this webinar and it's going to be posted on our YouTube and hopefully also on some podcast apps. I think we're still trying to figure that out, but I'm looking forward to it. So I'm Rebecca Lee. I'm one of the two co-founders of the California Psychedelic Bar Association. And my connection to the space is that I'm the general counsel of Journey Collab, which is a psychedelic pharmaceutical startup developing mescaline for the treatment of alcohol use disorder. And my co-founder, Paul Slattery, who unfortunately couldn't be here today, is the general counsel of Eleusis. As you can see from our YouTube channel, he's the real rock star of the organization. He's done really the lion's share of work with our previous webinars, which are, again, on our YouTube channel. So I'm very honored today to be speaking with Graham Pechenik, the founder of Calyx Law, which is a boutique patent firm that focuses on cannabis and psychedelics. Graham is a recognized expert, I'm sure I don't need to tell our participants, a recognized expert in the emerging field of psychedelic intellectual property. He's a registered patent attorney with nearly two decades of experience, both prosecuting and challenging patents across a wide swath of industries, including the agricultural, chemical, pharmaceutical, and biotech fields. Graham has a bachelor's of science from UCSD in biochemistry and cell biology and cognitive science with a specialization in neuroscience, which is very impressive. And he also has his JD from NYU. And before founding Calyx in 2016, Graham worked as an intellectual property attorney at Quinn Emanuel and Kay Scholler. I should also note that Graham is a member of the Chacruna Council for the Protection of Sacred Plants and is an editor at large at Psychedelic Alpha, where he writes about psychedelics IP, provides data for patent trackers, and helps maintain a psychedelics legalization and decriminalization tracker, which is super helpful for our community. And you can find him on Twitter at Calyx Law. It's CALYXLAW, where he tweets about psychedelic patents and other emerging issues in the field. Just for the record, I should also note that I'm very honored to have the privilege of working with Graham in my role as general counsel at Journey. And so I'm very excited to be talking with you today. Thank you, Graham.
Thank you. I'm very honored to be here. I should say I'm very honored to be working with Journey Collab. So it definitely goes both ways. And I can't imagine a more generous introduction. So thank you.
Well, I don't want to take it away from you. I mean, I know I just covered some of the highlights of your career, but just for the benefit of our listeners, I mean, many of whom I'm sure want to take notes from you and learn from your example. I would love it if you could kind of tell me in your own words how you got from doing biotech at UCSD to Calyx Law. Sorry, biochem.
Yeah, sure. And I think you captured like the highlights from a professional standpoint. So maybe like a little bit of the personal background.
Yeah.
So I mean, my interest in psychedelics goes back actually to when I chose those majors at UCSD. After my first psychedelic experiences early in college, became obsessed, I guess, but very curious about how my consciousness had changed and about the ways that just chemical compounds could have that effect. I sort of spent a long time reading like everything I could on Arrowwood. I had like the same Schwangel album. I think I played probably too many times on repeat, annoying my roommates, but just became pretty fascinated in, I think, the like ways that psychedelics interface with my own consciousness. And so that's why I chose to study neuroscience and biochemistry, and became very interested too in sort of a like history of it. I was probably fortunate, I guess, to be like raised by two kids of the 60s. My mom had gone to Berkeley in the 1960s, and my dad was a Zen Buddhist and sort of like grew up in Oakland with like a copy of Be Here Now on our coffee table and like Carlos Castaneda books on the bookshelf. So sort of had been like, even though my parents weren't really part of like the drug culture, like sort of steeped in that environment, I guess. And I've been interested in cannabis very much, both kind of as a stoner in high school, but also when 1995, 96, cannabis was on the ballot in California for medical use. One of the first things I did actually when I had my driver's license was like go and collect signatures for the ballot outside of grocery stores, and kind of became part of the sort of community of people that were interested in like changing that rule. And sort of through that and through then my interest in psychedelics, thought that law school might be a way of sort of staying involved in like drug policy reform or cognitive liberty. Actually, initially when I took my science majors, thought I wanted to do some sort of psychopharmacology. I had like gotten copies of PCal and TCal and thought like Sasha Shulgin would be like the inspiration for the type of scientist I would want to be. I got like no encouragement from that from some professors that I talked to about psychedelics who thought sort of psychedelics would not be a good career choice, but decided law school might be, even though naively, I guess, not realizing I'd have law school loans to pay off. And there was like maybe one paid academic doing a career in cognitive liberty, ended up doing patent law. So it's kind of like how I fell into patent law. And despite having written my law school sort of thesis on the problems of patents and how they keep drug prices high, I started my career and spent about 5 years working for branded pharma, mostly like Hatch-Waxman litigation, doing exactly what I was writing about my concerns about, which was like keeping drug prices high by extending drug monopolies and keeping generics off the market. So perhaps in some ways I'm kind of working my karma off through some of what I'm like doing now, I think. But yeah, so after law school, started at a firm in New York where I did mostly pharmaceutical patent litigation, like I mentioned, and then came back to California. So now I'm in San Francisco, Bay Area is like where I'm from, and did some more patent litigation, primarily for like Google and the like Google Android ecosystem. So there was a bunch of smartphone patent litigations, spent far too long and far too many days away doing depositions and like court appearances to, I guess, have any sort of balance in my life. And so after getting kind of burned out of that, decided, especially when California had cannabis again on the ballot in 2015 for adult use, a lot of friends of mine, a lot of people that I like continued to be in touch with in the cannabis space were like thinking about starting cannabis businesses, thinking of like taking their legacy businesses legal, and gone to like a bunch of the cannabis business conferences that had started sprouting up, and seen that there was an opportunity really for cannabis lawyers who back then there weren't very many because a lot of big firms were still hesitant to sort of get into that space, given some of the issues around risk and kind of money laundering even. And so just decided to sort of start a firm doing cannabis patents. It's probably a longer way of getting to psychedelics than I could have taken, but I guess after maybe 3 or so years of doing that, and about maybe 2 years back from where we are now, I saw the like psychedelics industry, so to speak, or then just kind of like the space just barely starting to emerge. And actually some of the same concerns that sort of also led me to start Calyx Law, which were the sort of balance of trying to protect innovation from some of the people I knew in cannabis, but also worried together with some of the people who I knew who were looking out. And I had actually been on like a case for a very long time against Monsanto, and there had been concerns in the cannabis space about what would happen if like a Monsanto or a Philip Morris filed a bunch of patent applications and bought up a lot of genetics or found a way to monopolize the cannabis industry. And so Calyx Law was, I think, started very much with that kind of balance in mind, like how do we protect innovation while also trying to ensure that the space, so to speak, can evolve in a way that protects like more of a diverse ecosystem and doesn't just allow for big monopolists to sort of come in and buy up the whole space. And so seeing that those were sort of controversies that were just starting to sort of poke their heads up in the psychedelic space, saw it as a way to sort of use my background in having worked on pharmaceutical patents, but also some of the like ways of being involved with some of those concerns themselves to join that conversation. So I've been really lucky to be able to sort of do both. And I guess that's kind of like the main tension of my work, is being someone who writes many of these patents. And the way I keep my lights on is, by preparing patents, but then also speaking out about the controversies of them, and trying to find ways to sort of navigate that tension has been, I think, a challenge, but also one of the things that keeps me really interested, and one of the things that I'm really glad has been a broader conversation in the sort of psychedelic space at large.
Yeah. Thank you for that. That's super interesting. It's also really heartening to me to hear, because I have a copy of Be Here Now on my coffee table, and I hope like be a good thing that I can do for my children someday. So yeah, no, that's great. I'm curious if you just tell me, what's the split right now in your practice? Like how much cannabis, how much psychedelics? Like, is that changing if you feel comfortable sharing?
Yeah, I mean, I'd say it's probably 90% at least psychedelics now. I mean,
Okay.
the way that patent sort of prosecution or like a patent practice often works is you bring on a client who wants to file a bunch of patent applications. You prepare and file those patent applications. It's generally a year before they'll file like their next application, a PCT or US non-provisional. And then you have 18 more months before that goes into US prosecution or national prosecution, and then maybe another year and a half or 2 years before anything really happens in front of an examiner. So oftentimes most of that work is like front loaded. So one of the things that often made sort of continuing to do business development a challenge is because you're like working with a client for a month or 2 months, and then you sort of don't have to talk to them very much for the next few years until sort of examination picks up, unless they decide to try to accelerate it. So because of that, since I've gotten started in the psychedelic space, I've not really been kind of like holding myself out as much as the cannabis lawyer. Like I haven't gone to the big conferences like MJ BizCon or any of the things. Definitely like during the pandemic, I mean, I didn't sort of like go out to try to take on more cannabis work. I mean, I think that the patent work in the psychedelic space is more interesting. I also tend to think it's more valuable in some ways too. And cannabis has changed a lot from when I got started. There were a lot of companies who were raising money trying to be sort of like a GW Pharma copycat. The GW Pharma has Epidiolex as an FDA-approved drug. And a lot of companies thought they would take sort of like the medical route, but there hasn't been as much, especially post sort of 2018, 2019, kind of like market crashed a little bit in cannabis. Like it's become more of a consumer packaged good.
Right.
The real interest is in not filing patents, but bringing on celebrity influencers. And so whereas in psychedelics, there's all these biotech and sort of small pharma startups where patents are really like their main asset and one of the most important ones. So I guess that all said, yeah, I mean, I'd still have, some legacy clients, so to speak, and applications that are like in prosecution, but it's not something I've had as much time for to go out and like continue business development in the cannabis space.
Okay. That's really interesting. Thank you for that. And then, I know, I think it's safe to assume that we have an audience of mostly attorneys on these webinars and on our YouTube channel, but and all of whom I think would be at least passingly familiar with patents and intellectual property law generally. But I like to kind of make sure that we all kind of have a common grounding, and so I was hoping that I could have you sort of set the stage, and before we get into the state of the field today and the controversies over it, kind of just walk us through, what kind of patents are we talking about when we're talking about the psychedelic patents that you're filing for your clients, or and if you could walk us maybe through the life cycle of a patent, how we get from idea to granted patent and so on.
Yeah, certainly. So I think kind of like I suggested a little bit, most of the companies in this space are like similar to like a biotech or kind of pharma startup in the sense that their main asset is going to be a chemical compound, whether it's a known psychedelic or many companies now new psychedelic compounds that they're taking through the FDA approval process or another regulatory approval process in Canada or in Europe. And so most patent applications are filed to protect the compound if it's a new compound. So of course, with known compounds like classic psychedelics, there are certainly strategies to file patent applications on them. And I'm sure since you mentioned controversies, we'll talk about some of those. With new chemical entities, the most important application that's generally filed is the one that protects the compounds themselves. And then there'll be many around them covering the sort of drug product, the formulation, the method of delivery with many compounds, the indication that they're being developed for ultimate clinical approval, methods of use for those indications. And then there are a number of companies who are not a biotech company that's bringing in drug through FDA approval, but working, for instance, with software, with could be different things for therapists, for doing for therapy, for a number of other things, virtual reality tools like biomarkers, diagnostics, sort of digital therapies. So a variety of things, but sort of the bulk of it really is with the actual drugs themselves that companies are looking at now. I think there's many dozens of clinical trials ongoing for a whole variety of different compounds, but that's certainly the bulk of my work, but also the bulk of patent applications that are just filed in the psychedelic space. Oh, and as for the life cycle, yeah, I mean, so the life cycle, as I kind of indicated, is generally a really long one, and there are ways to accelerate it. And in other spaces outside psychedelics, so for instance, in like software, companies will really rush to get a patent approved as quickly as they can because the life cycle of a software device or a piece of hardware is often much shorter because drugs take many years before they're even on the market, before there's even something to protect, or before there's a competitive product to keep off the market. There's no real interest. And in fact, there's actually a desire to get those patent terms as far into the future as possible and to sort of extend the potential ability to keep people off the market because sometimes a drug is making the most money at the very end of its patent life. So typically, in terms of just kind of the staging of it, companies will file a provisional or some priority document somewhere in the world. Then within a year of that date, there'll be a non-provisional filed, which is very often a PCT application because a PCT application allows for a national application to be filed in, now it's 156 different jurisdictions around the world within 18 months of the PCT or 30 months of that first provisional. And then at that date, that PCT application gets converted into national applications in whatever countries one would want. Often it's going to be US, Canada, anywhere there's a potential market. And then it may take a year and a half before an examiner picks it up. And then usually there's probably a year, 2 years, sometimes even a little bit longer back and forth with the examiner. So the patent examination process itself is sort of like a negotiation with a patent examiner. So, the patent applicant will present a number of claims. The patent examiner will review those claims in light of the prior art. So everything that's published or known to the public before the first filing date. And then the applicant and the examiner will argue about, whether the scope of those claims reads on any of the prior art, if it's narrow enough, if everything that's claimed is described sufficiently in the invention disclosure in the specification. And there's very often at least 2 or more sort of back and forth to the examiner. So, in terms of like written papers, sometimes like phone interviews. So that can take many, many years. And so often it might be 5, even 6 years after that first date before a patent is granted. But there's some examples of companies now, especially some companies that are, public, want to raise money, want to demonstrate to like investors or to retail investors that they have something that's protectable. They've kind of fast tracked it. So there's something called like track 1, where a application gets sort of pushed to the front of the line. And there's some other kind of like ways companies might want to do that too. I think we may talk later about how you can challenge a patent application. Track 1 also keeps applications because it allows them to be granted so quickly, sometimes not public, won't be published by the time it even gets to the point of allowance. One thing I didn't mention in terms of that timeline is patent applications are kept secret for a year and a half. So after you file a provisional, then after you file like a PCT, it's 6 more months before it becomes public. And that's pretty important in terms of companies not knowing what their competitors are doing. And just generally like the uncertainty in the space is pretty big, just because there's quite a long time, especially when the space is moving so quickly. I mean, if you think back like a year and a half ago, many of the companies that exist now like didn't exist back then. So like, what has everybody been doing? And there's also a number of companies who I understand have like, as long as you only file in the US, you can actually ask to have your application not published. So it's possible to keep it secret all the way up until the point when it gets granted. So one of the things that's sort of notable about the patent system is just how opaque it can be in terms of knowing what your competitors are doing. You have to be sort of on the lookout for what the risks are.
That's super helpful. Thank you. And then, yeah, sort of to kind of set the stage for some of the controversies I'd like to talk about with you as well. Like if you're someone who believes that someone else's patent is invalid, how would you go about challenging that patent, right? Like what opportunities and forums are available for that? Just
yeah, I mean, so there are a number of different ways that tend to kind of increase in expense and complexity as they get sort of further on. So as soon as a patent publishes and people know about the application, it's possible at that point to, depending on where it is. So if it's a PCT application, anybody can submit, even anonymously, prior art and have it made part of the file. If it's in front of a US examiner, it's possible once it's published within certain timeframes to present prior art to the patent examiner. And there's actually a nonprofit now called Porta Sofia that's been monitoring applications as they publish and then pulling together prior art to present that prior art to patent examiners to try to make the patent examination process take into consideration more prior art. And they have like a network also of researchers, and they've been scanning prior art that's been in libraries and things that may not be available to an examiner to make that then available to the examiner, and also put it up on their system that would be searchable for somebody too as a database. But so there's those ways of presenting prior art. And then once that's done, the person who sends that to the patent examiner doesn't have any further involvement in it. And you can make some arguments. You typically present what's called a claim chart, where you put the claims kind of on one side of the page, and you put the prior art and you put like quotes from them to sort of match it up. But there's no way to actually like interact yourself or speak with the examiner to try to argue. Once a patent is granted, then there's a period of time too to submit a challenge afterwards. So there's like a post-grant review or inter-parties review, where a challenger, any challenger, can basically try to get a administrative board to review the patent once more. And then you have the opportunity, for instance, with a post-grant review, to argue to the board yourself, to present evidence. I think we'll talk about in a kind of specific example of that, but that's something that can be done. Of course, presenting just prior art during the pendency of an application is quite inexpensive. I mean, obviously, there's the time and resources it takes to pull that information together, but then it's almost as simple as just filing it with the patent office. After the patent is granted, the filing fees for an administrative challenge are close to $50,000. So that's obviously something that's a little bit more out of the range of just like an interested member of the public who is just concerned about a particular patent application. So it's somebody who really has an interest in seeing that patent perhaps being narrowed or invalidated. And then once those opportunities pass, really the only other way of challenging a patent is in district court litigation. District court litigation, for, I guess, on one hand, there's restrictions about who can even file them. So it's not possible to have a declaratory judgment invalidity case unless you have some threat of being sued yourself for patent infringement. So that's not available to everybody.
That would be the case of controversy requirement, right?
Yeah. I guess we are speaking with lawyers here, so.
Yeah, right. I mean,
so,
you gotta have Article 3.
Yeah, I mean, like Hatch-Waxman, for instance, how to make it a sort of artificial act of infringement, filing that paragraph 4 certification when you, like, as a generic, want to launch into the market, so that you would have the ability to then sue for invalidity. But then besides that, yeah, so if you are like sued for infringement and you want to invalidate a patent, it might cost hundreds of thousands, or most likely even more. I know the IPLA collects statistics for how much patent challenges cost, and they're often several $1 million, especially as as a defendant in a patent infringement suit, as in a alleged infringer. You have to hire experts, and just getting through sort of the early stages before you can even get to like summary judgment through what's called like Markman hearing, where you present your claim construction, what the claims of the patent application mean. Those are often pretty expensive. So yeah, once a patent gets granted, it can certainly serve pretty powerful chilling effect, even if there's really strong invalidity arguments that could be leveraged against it.
Thank you, Graham. That's super helpful. So yeah, having kind of set that stage for everybody, I wanted to talk about some of the controversy that has been happening in the field, maybe starting with some of the patent applications that I think really kind of I think triggered some of this discussion in the psychedelic space. And I noted this was a couple of years ago. You wrote on Twitter that in one of Compass's original patent applications, they appeared to be trying to patent the basic components of psychedelic therapy, because they were claiming administering psilocybin in, quote, a room with substantially non-clinical appearance, and that they had other methods where the room comprises soft furniture, the room is decorated using muted colors, the room comprises a high-resolution sound system, the room comprises a bed or a couch, things like that, right? Eye masks, etc. And the question that you asked at the time was like, if those claims, if a patent had been granted, including those claims, could they stop others from offering psychological support using that same methodology? And so, my understanding is, I guess, that Compass did eventually abandon those claims. But I would just love it if you could talk to our audience about what you found concerning about the scope of those claims as originally drafted, and also sort of taking a step back, why you think like that touched such a nerve in the community, because it was in Vice, it was in a lot of other publications people were talking about it, and still are talking about it.
Yeah, yeah, no, definitely. I mean, maybe I'd start by saying I'm not sure they necessarily abandoned it, because I think they can maybe revive those claims. I don't think they would. And I think Lars, when he was still with Compass, said on some webinars that they were not going to pursue them. I think that may have been confirmed by even Christian later. So I guess in effect, they probably have abandoned them. I mean, I think maybe one thing that's worth mentioning is PCT applications, when they're filed, there's no limitation on the number of claims that they can contain, unlike in the US. So part of the reason they sort of abandoned those claims is once they entered the US, they had to select 20 claims. And in the PCT, they had hundreds, and these are among those many hundreds. So it's hard to know if they sort of ever intended to pursue them, and if the controversies made them drop it, or what their initial intents were. Certainly, I don't know. I think why it got so much attention from people and aroused so much interest is because just the fact that it was, I think, fairly clear that those types of things that they were claiming are well known and being used already, and had long been used as part of psychedelic therapy, and had long been described. And I think the main controversies are patents. Patents, of course, have to claim something that's novel and non-obvious. And so, unlike some of other patents that had been controversial, like Compass's polymorph patents, are, I think, difficult when you get down to the sort of technical details of, what's a polymorph, what is a crystal form. Even looking at their claims cover, particular X-ray diffraction peaks. It's the type of thing where I think it's hard to have a kind of gut reaction to whether or not just intuitively those things sound like there's something that should be in the public domain. Whereas these things seem very obviously like, how can somebody patent the use of an eye shade or hand holding, or the sort of decor in a room? The thing that made it stick out to me at first, I think, was actually the sort of disconnect between, and this was like the day that I first posted it, was after a press release from Compass saying that they had been incredibly thankful for the contributions of all these experts around the field. This was just when they had published, or when a article had published in Frontiers in Psychiatry on like the training program and the psychological support, saying that they were thankful for all this, all these efforts from different experts around the field, how they appreciated everybody's collaboration, how they hope that this would allow for future collaboration, and be a sort of training model that others could follow. And so I thought there was like a disconnect between that and the fact that many of the things that were laid out in this paper were things that had been covered in their application, and had those claims been granted, that could have prevented the types of things they were saying were things they hoped would be available to everyone, to have them have exclusive rights over that. I mean, I think there was, and probably any patent lawyer would tell you, there was no chance that the sort of those claims would have been granted as broad as they were written. But I think it was a really good opportunity for there to be conversation around what is appropriate for patenting. Just seeing how patents, if they're potentially not examined properly, they could claim things that should otherwise be in the public domain, and just seeing that there are dangers there. And so I thought that was a important kind of point for just general conversation around kind of how patents could be controversial, how bad patents potentially could be granted, and kind of what the effects of those bad patents could potentially be.
Yeah, no, that's super helpful. And yeah, I remember also being really concerned by the scope. But since we did just touch on the polymorph patents as well, I'm curious, because I know that there's also been some activity around that, and I believe it was the organization Freedom to Operate that might have challenged that granted patent. So, I was wondering if you could talk a little bit about that controversy and what the outcome was to that challenge to the polymorph.
Sure. So there are also these other patents that now I think there's at least 5 granted that cover the specific polymorph, or 2 different polymorphs actually. So there's a polymorph A and there's a hydrate A. So for those, I suppose, who are unfamiliar with polymorphs, when a chemical compound is crystallized in a drug product, so like even salt, for instance, if you can imagine, like, salt is specific molecules, but then when it's like in a greater amount of those molecules, they form different types of crystals. I think the way most people learn about them in like chemistry classes, for instance, with carbon can form diamond, and like graphite, like a pencil, and those are different polymorphs, and obviously have very different appearances, and are very different in terms of their properties. So psilocybin forms a variety of different crystalline forms, and Compass had patented one specific one of them. And these patents were challenged by, as you said, Freedom to Operate. So Freedom to Operate is a nonprofit that apparently was founded with the purposes of challenging overbroad patents. I think, at least from what I understand, funded primarily by Gary Turnbull. And these patents were challenged because the argument is that that particular psilocybin polymorph is one that was the same that was produced by prior methods of synthesizing psilocybin. So psilocybin, of course, was first synthesized back in the 1950s by Albert Hofmann, and synthetic psilocybin has been manufactured back then by Sandoz when Albert Hofmann, after he first synthesized it, and then by other companies since then. And so, as part of this particular challenge, I think there was a group of scientists that collected over 50 samples of psilocybin from like all around the world, and did studies to show that, at least help them argue that the type of polymorph that was protected by Compass's patent, or claimed in Compass's patent, was the same as some of these prior art polymorphs. So that Freedom to Operate challenge was filed. It was a post-grant review, so one of these administrative reviews. They actually filed 2 most recently, and then there was one after Compass's first patent was granted several years ago, that, similar to these past 2, didn't get past the institution stage. So basically, the sort of first step in bringing an administrative challenge is asking the board just to hear the case. So you have to present evidence that it's more likely than not that at least one claim of the patent will be found invalid if they hold a hearing. And if they institute it, then you get to have arguments before the board, and bring forward your evidence, and have the board consider it to decide whether the patent claims really should be found invalid. So it didn't survive in that institution stage. So the board found that it was not more likely than not that any patents would be invalidated. And from what's been reported by Shayla Love and I think others, those challenges cost over $1 million in total. So that goes to show just how expensive it can be. And that, I think, was maybe a little more work than can be done in other types of challenges, and that they did collect all these samples around the world, and they used expensive equipment and people's time, and had many experts, and I think had some of the sort of world's leading crystallography experts to submit expert reports. So there's quite a lot of work.
Wow.
But definitely goes to demonstrate how difficult it can be, because they certainly had, at least as they expressed it, some certainty that these applications should have been found invalid.
Right. So $1 million just for Freedom to Operate to present their case to the board.
Mm-hmm.
That's pretty
Yeah, I mean, and one other thing that's kind of notable about it too, I think, is even had they won and invalidated the claims of these 2 applications, like I said, there's, I think, at least 5 now in the US that have been granted. And the way patent prosecution works, and this is something that people are sort of trying to figure out, whether they should have the there be legislative change to reduce it, but one can file continuation applications as many times as one wants. So during examination, for instance, like while you're negotiating with an examiner and the examiner, refuses to grant the application, you can just keep going back and forth, sort of as many times as you want to continue paying, because every two like interactions with the examiner, you have to pay to like request to continue examination. But even after you get a patent granted, you can continue as long as that specification that you filed, as long as that first application still has more patentable subject matter, or you can even file claims that are just slightly different than your other claims. You just keep getting patents granted and granted. So even if Freedom to Operate had succeeded in invalidating those two applications, or those two granted patents, there could still have been another half dozen others. So it's pretty difficult to try to stop that kind of
Very, very expensive game of whack-a-mole is what it sounds like.
yeah, that's a much faster way of putting it, but
I don't mean to be flippant, but and I also don't want to just pick on Compass, just on one company. I know you also spoke recently about the fact that MindMed was recently granted a patent for what they call a composition comprising an empathogen or entactogen and a psychedelic in the same oral dose. So, which means basically combining LSD and MDMA, or what recreational drug users have called candy flipping for presumably several decades now, at least. And so I'm just curious if you could tell again our audience a little bit about what the status of that patent is, and any challenges to it and concerns that you have.
Yeah, definitely. And I should say, I mean, I don't, despite speaking a lot about Compass, like have for the record anything against them either. I mean, I think there has been this like long narrative, and perhaps a lot of it is just because of the sort of baggage that they have for being one of the first in the space and having some of the first controversies that they've kind of continued to stay in the spotlight. I think it's likely and true that many other companies are filing very similar types of patents as they are, and you don't get to sort of share the limelight that they do. So they've been kind of a lightning rod. But the MindMed application, yeah, I mean, I think this is another good example of an application where it seems like it should be very clear to most people that this is not something that is, I think in a lot of people's minds, worthy of a patent being granted. So I think anybody who's familiar with psychedelics knows that psychedelics and pathogens or entactogens can be taken together. As you said, like there's the candy flip, there's other psychedelics and entactogen combinations, there's hippie flips and other things too that people will be familiar with, certainly. So how can it be that a company can obtain a patent to it? And so the patent examiner actually was aware that there had been combinations. And in fact, there were combinations that were brought to the examiner's attention, but this examiner felt that putting the two together in a single pharmaceutical formulation, so instead of taking a tab of acid and taking a capsule of MDMA together at the same time, if you put them both in a single tablet, that was enough to convince the examiner that this was an invention. So I think that sort of shocked many people that was sort of the bar. I think it's maybe a example of an examiner who might be on the easier end of the spectrum in terms of getting things granted. I mean, I'm sure for lawyers who are listening, maybe aren't patent lawyers, but if you've litigated, you're familiar with kind of the roulette sometimes with getting judge selection. Sometimes some judges you're really excited to get, and sometimes it's going to be a really tough battle in front of them. And the same is definitely true with patent examiners. There's a lot of statistics that are available on people who practiced for a while in front of a particular group of examiners, because examiners are sort of sorted into different art units, and there's only kind of 10 or 12 in every individual one. And so you may be in front of the same examiner a handful of times, and so you may know who are the easier ones, and who are the ones that really kind of put you through the ringer. So whether or not this is something that can survive if it were challenged, if I were gambling, I would say probably not. But yeah, so I don't know anybody now who's challenging it. I think it's possible that somebody will, but I think for somebody to want to pay the $50,000 in filing fees just to file a type of post-grant review, that would take somebody who's motivated enough, who may be bringing something to market that could be potentially covered by it. So that would be in the scheme of things, the choice of bringing that and trying to invalidate it now versus potentially infringing a patent later and having to fight back in a more expensive district court litigation could sort of drive that decision. And then there's a lot of technical issues that I know are among lawyers, but probably not to get bogged down in the time, because there are estoppel issues around bringing post-grant reviews too. So one of the concerns would be if you bring a post-grant review, try to invalidate a patent, are unable to, that leaves you open to not being able to make those same arguments as defenses if you were then later sued in district court. So
Really?
There's also kind of a trade-off there.
Yeah. So I guess, maybe we might see another challenge by an organization like Freedom to Operate, right? If they can find some workers in the traditional market who might be able to attest that such a thing has been done before, combined in a single dose,
definitely.
but maybe not from a competitor, is what you're saying.
Yeah, although for people who have been watching the Freedom to Operate cases very closely, one of the things that Compass argued was that the real parties in interest were not only Freedom to Operate, but also more broadly could have covered others who, I think their arguments would have been the ones who should be bound by the estoppel, had there been any. Those sort of didn't get reached because of the fact the case never got instituted. But had there actually been a administrative hearing and had Freedom to Operate lost, I can imagine those would have probably come up later if, say, Compass had sued USONA or somebody else who arguably had a relationship, or who had a relationship that Compass could have tried to make an argument, could have been bound by something like that.
That's really interesting. So Freedom to Operate, obviously they lost out of the starting gate, right? The board held that there wasn't, they hadn't shown it was more likely than not that the claims are invalid. Would that be estoppel as against, say, a USONA or something else? Could Compass make that argument in an infringement case down the road? Or is it not, because it was,
I mean, that's a good question. I don't believe so at the institution stage. So because they weren't reached on the merits.
Okay.
I don't think, I mean, I think here too, the questions around the real parties of interest, the Patent Trial and Appeal Board didn't reach those either. So I guess it could be relitigated potentially. I mean, I'm not a really a litigator anymore, but so something I'd have to look into. But I don't think so sitting here.
Sure. Yeah. As another recovering litigator and not in the patent field, I also feel like that's all fallen out of my head. So I'm sorry to put you on the spot.
Yeah. No, that's quite all right.
So I'd love it if you could talk a little bit also about the patent tracker that you have for psychedelic alpha. Are there any other applications that you're watching or that you're particularly interested or concerned about?
Yeah, I don't know that I have any specifically in mind that I'm particularly concerned about. I mean, I think one thing that's maybe, although probably more of a personal note about the patent tracker, I mean, going back to Compass too, the sort of genesis of the patent trackers was when there was an article back in 2019 first published about the fact that Compass had filed applications on psilocybin before those applications had even published. And just starting at that point, I decided that I would search to see if there were other psilocybin related patents. And then there weren't very many. I think that the patent tracker, when it was first put together, was maybe a dozen patent applications. And that patent tracker happened to be a public Google Doc that Josh Hardman, who is the founder and editor of Psychedelic Alpha, kind of picked up on a web scraper and reached out to me. And I think in terms of the sort of serendipities of my career and the serendipities of the space, that's probably one of the biggest ones, because that's when we decided that this would be something to make actually a public resource. At that point, it was just something I was occasionally showing to clients. And then we've been spending a lot of time adding to it, obviously. But in terms of problematic applications, I would say almost I'm maybe thankful that there have not yet been, at least that I've seen, many applications that are filed by what some might call patent trolls or non-practicing entities, companies who are not trying to protect a program that they're doing. So for the main applications that have been filed, I think are companies who are looking to protect the work they're doing, looking to try to raise investment around the work they're doing by showing that it's protected by patent applications. And one of the biggest concerns generally around patents is that if they fall into the hands of a company who wants to try to sue just for purposes of trying to extract settlements, oftentimes because of the way patent litigation is very expensive and the sort of asymmetry of trying to defend litigation, companies can use patents sort of extortionately. So I think that might be several years down the road until companies may go bankrupt or may sort of sell some of their assets to raise money. And then there's a number of companies who, as their entire business model is just to take patent applications and look at who potentially could be doing something that's covered by them. And even though there's not a lot of patent litigation in the pharmaceutical space, much of that is because pharmaceutical companies are the ones who are generally filing, even if it's hundreds of patents, filing hundreds of patents on their own drugs. Whereas here, like with psilocybin patents, there's dozens of companies filing psilocybin patents. And so there's a lot of patent applications that potentially could be protecting or covering things that a whole number of companies are doing. And because of the way that like the patent examination process is fairly imperfect, and patent claims themselves, just because of the flexibility of language itself, they can be arguably asserted against a number of different companies potentially. So that's the kind of thing that I would be most worried about. I think is potential for the sort of patent trolling that is generally not actually contributing any economically beneficial activity, but is really just kind of purely rent seeking. But at this point, I think just still watching out of interest and curiosity. But since nobody's really able yet to make any money from the drug development programs, there's not a lot of targets yet for infringement damages. But I think that'll come.
Yeah, that makes a lot of sense. And I hadn't considered that horrifying possibility that the kind of patent troll behavior that you see in the software industry could come to pharmaceuticals because of the sort of fragmented nature of psychedelics and the state the industry is in right now. But that's a sobering thing to think about.
Yeah.
So I'm interested if, you laid out, I think, pretty clearly, like a lot of the concerns that you have about some of the kinds of patent applications that are out there and some of the concerns with the system generally. I'm sort of curious, there's been a lot of silence, I think, from some of the larger pharma players in this industry in response to, a desire to have a kind of more open science pledge. Do you think there's a middle ground here, right? I mean, I know the system is what it is, but, is there a way both for for these pharmaceutical companies to get the investment money they need to get through the FDA process, which I was kind of horrified to learn when I first joined Journey. It's hundreds of millions or even billions of dollars for a single drug, right? Where we need to be able to reward investors for that kind of substantial stake, while at the same time not making sure that not preventing individual therapists or researchers from doing their work. And I'm curious if you can talk about like patent pledges or other ways you see to kind of try to thread the needle there.
Yeah, no, I mean it's a really big challenge, and it's a difficult problem to solve, given that I think it's apparent that without some sort of incentive, the great expenses, the hundreds of millions of dollars potentially, investors are very unlikely to sort of put that in. I mean, so there's some examples of, certainly, I mean, everybody knows that the industry really was founded on the back of like maps, and we know Usona too is fairly far ahead in drug development, and both of them have made most of their money through philanthropy. But in terms of being able to sort of pursue at a broader level that sort of pharmaceutical development, without some sort of protection or without some sort of incentive, it's pretty difficult, if not impossible. And on the other hand, we know that patent applications can create these potential controversies and can potentially create sort of chilling effects for even innovation itself. And the whole reason for the patent system is to encourage innovation. So how do we allow that encouragement to take place without sort of running into the difficulties that we see? I think there are, you know, we should say that like the patent grant itself is sort of designed as a tool for excluding competitors, but it needn't be that. And the patent grant too can be used in fairly flexible ways. And certainly the full scope of patent exclusion um, is something that can be chosen whether or not the company wishes to um, use it in sort of anti-competitive ways, or wishes to use it in more ethical ways, or wants to find a balance between obtaining kind of the profits that it thinks kind of it deserves, or just obtaining the sort of reward that is sufficient to encourage drug development, and provide enough funding for that, but is still allowing there to be other broader or sort of different benefits. And one of the things I think I'm excited about right now, and there's an article that's coming out in the next, I think maybe week or two, is working with Chris Burns, who's at Calyx Law with me, who actually kind of I met because he had been working at RPX, a company that's provides insurance basically against patent trolls, and so I've been thinking a lot about patent trolls. And he's been with a background really trying to understand like kind of creative and imaginative ways of using patents and IP to like sort of both pursue ethical ends, but also prevent some of like the greater controversies around them. So have written an article together with Sava Kardamalides, who has worked for a long time on a sort of alternate economic system called for like prizes instead of patents. So rather than having a patent grant, this is a way of like having a kind of like a prize fund that could be provided. I think there's other ways too. I mean, so you mentioned like patent pledges. I mean, one of the things that I think I've seen from different companies in this space is oftentimes people want to follow, for instance, many people may have read, just familiar with the psychedelic space for a while. A couple of years ago, Bob Jesse put out a statement on open science and open praxis, basically saying that like people should not file patents. If they did file patents, they should allow licenses to everybody on the sort of minimal terms necessary just for kind of administration of the just the technology itself. And a lot of companies, I think, wanted to be able to pursue that sort of like open science, but found that if they did that, it was hard for them to attract investors, and it was hard for them to find ways to even continue sort of the work that they were doing. And so there has been this need to have some sort of a balance. But I think, as you mentioned, with concerns for therapists, for instance, or researchers being sued for infringement, the sort of chilling effect I think that I mentioned definitely extends to like small businesses, like therapists and researchers, and a lot of the controversy I think over Compass's patent, the first one that we discussed with the hand holding, was people saying, well, how would this affect me? Like, if I wanted to provide psilocybin therapy, like, could Compass sue me? I think this was true too, like back before even their Compass's first patent had published, when it was known that they had filed patents on just psilocybin, but it wasn't known that it was a specific polymorph. And there were concerns about, well, would this cover just the use of psilocybin mushrooms, or would this prevent me from even growing mushrooms in my closet? I mean, I think there's statements from like Christian or Lars saying we're not here to keep people from growing their own mushrooms. So there has been like this kind of confusion about it. And I think one of the things that companies can do to prevent that type of confusion and to sort of provide assurances, and I think assurances that are important just because of the fact that the scope of a patent can be so uncertain, is to really make it clear that companies are not planning on taking certain actions and aren't and don't want to threaten certain behaviors. And I think those types of statements can go really far in making clear to people sort of where the boundaries of potential infringement can be. And I think with sort of big competitors in the market, a competitor can hire a patent lawyer to write a freedom to operate opinion and say, you're not going to infringe these claims. But with therapists or researchers who may not want to pay the money for that type of opinion, it can have like a real effect, even if like a patent lawyer might say, this is not going to be a threat, like being able to like provide that affirmatively. But another real advantage with those types of patent pledges is one of the things that we said was a concern is patent trolls. And so a company may have patents, and that company can be very ethical, and everybody can think that company is going to be very ethical, and the company can provide assurances both through its like actions and through its statements that it isn't and won't ever sue particular groups or hold out their patents in a particular way. But those aren't really legally binding, and they're certainly not legally binding to any sort of future, whether it's somebody that gets a patent application later, or maybe a licensee, or maybe more broadly than the company. So putting something in kind of legally binding terms, like in a patent pledge, can also provide like assurances that can run downstream with the patent itself. So that was a very long and winding kind of non-answer, because I think there certainly are a lot of really creative ways that people can use the patent system to like avoid some of the concerns that are sort of front and center with certainly some of the companies.
Yeah, it's super helpful, and I really appreciate that. I know we're at our scheduled time, but if you have time for just one last question, this is one that Paul came up with, which I really enjoyed hearing everyone's answer, all our interviewees. But it's a human interest question, and it's do you have a favorite fictionalized depiction of psychedelics, like in a movie or a TV show or a book? And could you share that with us?
Yeah, no, it's a good question, and it's one I was trying to think about, and it's really hard to come up with a specific one. And then I thought I had a good specific one, but then actually I listened to Matt Zorn, who I was very fortunate to work on the DEA case with, and had heard that Matt Zorn said it was very cliche to call it out. So I'll call it out because I think like actually one of the best depictions of like a psychedelic experience I think does come from Fear and Loathing in Las Vegas. Like that hotel scene will sort of forever stick in my mind. And I think anybody who's like seen any kind of like Vegas carpet would immediately resonate with like the ways they portrayed some of the patterns. I think the sort of the book, it's maybe not depicting specifically psychedelic experiences, although it does describe many. But the book that really got me first interested in like learning more about the history was Electric Kool-Aid Acid Test. I definitely think like that's almost like required reading to some degree, because I think it really presents like the sort of cultural milieu of the 60s in a way that shows how important like psychedelics were for it. I think if I had to pick just a particular scene, I think there's a scene in Gravity's Rainbow where they're eating a bunch of different candies. And the whole book is probably not worth reading for this one scene because it's kind of a monstrous tome, but I think it's available online. But maybe I can send the link. But
That would be
like
great.
just yeah, the sort of like sort of like intellectual fireworks, I guess, and kind of weirdness and of like a psychedelic experience, I think are captured very well, and like describing all these like different types of candies in this very weird way, in this scene of the main character and some other characters like eating all these different candies. I really can't do it justice. And I think last one I had four. I know you said one last question. It's going to be a long answer, but I think also the movie Waking Life is one where just I think the the film resonates really well with sort of the psychedelic kind of
Interesting. I haven't seen that one. I'll have to add it to my list.
Yeah.
Waking Life.
Yeah, it's Waking Life. Yeah, it's a Richard Linklater. I think
Right.
it's psychedelic sort of in its visual effects because it's like it's done with this type of animation called rotoscoping, where it's like filmed live action and then there's like animation over it. It's very psychedelic in terms of like the philosophy that they discuss, and it's yeah, I recommend it.
Awesome. Well, thank you so much for that. And thank you so much for this incredibly interesting and informative discussion. I really appreciate you taking the time with us. And, it's always great to see you and great to talk about these things and a lot of food for thought for our listeners. I would love it if you could send me that article that you mentioned so that we can put that in the
Yeah.
follow up. I'm sure people will be interested to read, and I'm interested to read it. So, but thanks to everyone who came live today and anyone who's watching on YouTube. Again, this is Graham Pechenik from Calyx Law and for the California Psychedelic Bar Association. Thanks, Graham. I'll talk to you soon,
Yeah.
I'm sure.
Thank
Okay.
you so much, Rebecca. All right.
Bye.
Bye.